She is saying blatantly that prosecutors offered Josh Ellis this deal in the interest of equity and anti-racism. That they offered a cold-blooded killer who'd put a bullet in the brain of a 25-year-old he claimed to love. That they're giving him, and they agreed to a sweetheart deal without consulting the family in the interest of equity and anti-racism. To argue that Joshua Ellis deserves a lighter sentence because he's black is to argue that WENDI Traynor deserves less justice because she's white. I want to frame all of this through the lens of what our criminal justice system is supposed to be about. If our justice system is working as intended, it is not supposed to consider someone's race. It is not supposed to consider someone's socioeconomic status. That's why Lady Justice wears a blindfold. And I'm not going to say that there have not been times in our nation's history where that sentiment was simply not true. I'm not going to argue that there have not been times in our nation's history where people based on the color of their skin were treated unfairly in this country. It would be ridiculous for me to suggest otherwise. What I cannot understand, what I refuse to accept is the idea, though, that to fix the wrongs of the past, to somehow have a criminal justice system that is working, that we need to go backward. That is what's happening right now in the WENDI Traynor case. For those of you who haven't been following this story or maybe are new to the podcast, WENDI Traynor was 25 years old when her estranged boyfriend shot her in the back of the head in her apartment in Milton, in Pierce County, Washington. She had been in a relationship with him not too long, but they were in love. They moved out of state to Kentucky together so he could be closer to family, and she decided that she wanted to leave. And by all accounts, according to her friends and her family, it had become a toxic relationship. And Joshua Ellis, her boyfriend, who was 27 years old at the time, came back to Washington from Kentucky and shot her in the head, left her body to rot for a week for her father and for her uncle to find. It was a clear case of domestic violence committed with a firearm. It was one of the most egregious types of homicide that you can have. Someone who, if I can't have her, no one will, snuffed out the life of a beautiful, vibrant, brilliant young girl. Now, I feel forced to bring up the fact and talk about race in this case because there are individuals involved in this case who are obsessing over it. Josh Ellis is black. WENDI Traynor, as you've seen in her pictures, is white. And Josh Ellis's defense counsel wants you to believe that that is critical to the outcome of his sentencing on Friday. Now, a little bit more background on this case before I get into some of the really horrifying statements that Josh Ellis's public defender has made in pre-sentencing memorandum. So this is the second time, actually, that Josh Ellis is going to be sentenced for WENDI's murder. He already went to trial back in 2019. He was convicted by a jury of his peers of second-degree murder. A judge sentenced him to the maximum allowed under law. A judge sentenced him to more than 20 years, including a 60-month firearm enhancement. And the judge at the time said that he had never seen someone treat a dead body as callously as Josh Ellis had. He had never, referring to the fact that Josh Ellis left this person he supposedly loved there to rot on the floor. There was one witness who testified that they believed Josh Ellis might have returned to the home to feed his dog, while the body of his estranged girlfriend was just sitting there decomposing. And the judge at the time in 2019 said, if I could give you more time, Josh, I would. He felt that 20 years plus a mandatory sentencing enhancement for using a firearm was not enough, but it's what he could do. It was within the standard sentencing range that is set out by law. So Josh Ellis is convicted in 2019, and he was able to successfully appeal his case because of something that happened during jury selection that amounted to prosecutorial misconduct. So he has constitutional rights to a fair trial. That's fine. I mean, that's how our system works. So he convinced the Washington State Court of Appeals to throw out his conviction. WENDI Traynor's family was disappointed, but they said, you know what? This doesn't change the evidence in the case. He's already confessed to killing her. So yeah, they were gearing up over the summer for a second trial. They didn't want to go back to a second trial, but they want justice, obviously, for Wendy, so they were prepared for it. And then they were absolutely blindsided at the beginning of September when they found out that prosecutors in this case had reached a sweetheart plea deal with Joshua Ellis without consulting the family. A sweetheart plea deal that could allow Joshua Ellis out of prison by 2025. He killed Wendy Traynor in 2017. We're talking about just over 8 years for a domestic violence homicide with a gun. The family was baffled. Why would they not have been consulted in all of this? And at the time, we were covering the case and we did some reporting on this where I talked about the real disappointment in the prosecution. You can go back and read the story. It's called Justice and Cowardice Are Not Compatible. And it dives into why prosecutors felt the need to offer Joshua Ellis a sweetheart plea deal when they could have easily taken this case to trial, secured another conviction. They'd done it before. The facts of the case hadn't changed. And why they would offer such a sweetheart deal for a crime that was so egregious. And in that story, we got into what had been at the time just some rumors in the legal community in Pierce County. Ann Bremner, a longtime attorney, was working with the family pro bono, and she had heard that prosecutors were scared that public sentiment around race and criminal justice had changed so much since 2019 that they were worried that taking it to trial might not have the same outcome because of the color of Joshua Ellis's skin, because it was a black man on trial. So rather than consulting with the family, rather than saying, who cares what the public sentiment is? Who cares what politics is around race and criminal justice? We're taking this guy back to trial because he deserves to be held accountable for what he did. And that's why I said at the time that the actions of the prosecutors were absolutely cowardly. And now it seems we have evidence to prove, to show, that the reason prosecutors agreed to a sweetheart plea deal for Joshua Ellis is because of the color of his skin, which is completely contrary to what our nation's criminal justice system is supposed to be about, which is completely contrary to the idea of Lady Justice wearing a blindfold. So what I want to take you through, and I will warn you, it'll make you sick to your stomach. And that's what I heard from Wendy Traynor's mom when she showed me these pre-sentencing recommendations and memorandum from Josh Ellis's public defender. It made her sick to her stomach. She said she felt like puking, and I don't blame her. She has every right in the world to be disgusted, because what's happening behind the scenes right now is that Josh Ellis's public defender has been, since mid-November, filing a series of memorandums to the judge. It's a new judge who's going to sentence Josh Ellis on Friday, blatantly arguing, that because of the color of Joshua Ellis's skin, he is entitled to the lowest sentence allowed by law. That is not hyperbole from me, as you will see as I go through aspects of this sentencing memorandum. She is blatantly making this argument. The public defender's name is Mary Kay High. I've talked about her on this show before because I was shocked, utterly shocked, at the last court hearing, her disregard for the feelings of the family, how she treated the family. And I said at the time, I'd never seen anything like it. And so perhaps it isn't surprised that this public defender, paid for with taxpayer funds, if you're a Pierce County resident, keep that in mind, that this public defender is actually arguing that Joshua Ellis, because he's black, deserves the lowest sentence that the law allows for. So let me take you through this sentencing memorandum. And again, it is absolutely going to piss you off. And I have stewed on it. In fact, if you saw a Facebook post that I put up the other night, I was awake at 3 a.m. thinking about it. Because it made me so mad for Wendy's family and so disgusted by the state of our criminal justice system, by these efforts toward equity, that we would actually look at the color of someone's skin blatantly when deciding what justice looks like for someone like Wendy Traynor. So at the very beginning of this sentencing memorandum, again, Mary Kay High, the public defender, makes it very clear the argument that she's going to make to the judge in this case. She writes, on June 4th, 2020, as our legal community, our local community, and our nation reeled from the persistent and ongoing violence by police and the criminal justice system against Black and people of color, Our state Supreme Court issued a letter to the judiciary and legal community. The court stated unequivocally that we owe a duty to increase access to justice, reduce and eradicate racism and prejudice, and continue to develop our legal system into one that serves the ends of justice. In that regard, she says, Joshua urges you to follow the agreed recommendation and give respect to the courage and integrity the current deputy prosecuting attorneys have demonstrated in making this recommendation and their commitment to equity and anti-racism. There it is, from Joshua Ellis's own public defender. She is saying blatantly that prosecutors offered Josh Ellis this deal in the interest of equity and anti-racism. That they offered a cold-blooded killer who took a gun to the head, who put a bullet in the brain of a 25-year-old he claimed to love. That they're giving him, and they agreed to a sweetheart deal without consulting the family in the interest of equity and anti-racism. And references, again, in the sentencing memorandum about, the state of criminal justice in June of 2020. As if what happened with George Floyd in Minneapolis has anything to do whatsoever with Josh Ellis murdering Wendi Traynor in 2017, 3 years before that even happened. As if it has any bearing on it whatsoever. So Mary Kay High in the sentencing memorandum goes on to suggest that Wendi Traynor's family, in asking for the judge, because keep in mind, Judge Andre Penoliver, who is going to be the sentencing judge on Friday, has ultimate discretion. He does not have to stick to the sentencing recommendation. He does not have to stick to the plea deal. He can throw it out. He can give Josh Ellis a much higher sentence. And that's what Wendi Traynor's family is asking for. They want the sentence he was given the first time he was convicted. They want the mandatory sentencing enhancement for him using a firearm to be put back in place because this deal got rid of it. So in this sentencing memorandum, Mary Kay High, the public defender, has the audacity to suggest that Wendi Traynor's family simply wants retribution because of the color of Josh Ellis's skin. That it's not retribution they want because their 25-year-old girl was taken from them. Not retribution because her dad and her uncle had to find her decomposing body. Not retribution because he took her life. Retribution, that sense of retribution they want is because Josh Ellis is black. The memorandum reads, a recent study revealed that beliefs about the importance of retribution and beliefs about race are intertwined in America. It showed that the level of support for retribution as the primary justification for harsh punishment correlates with bias against African Americans. The memorandum goes on to even use race as an excuse for the fact that Joshua Ellis, who, by the way, claimed self-defense, a claim that was easily disproven at his first trial. The memorandum even goes on to blame race for the reason Joshua Ellis left Wendi Traynor to rot, left her body to rot, because he was scared because of the color of his skin, about what police might do to him if he turned himself in. The memorandum says Joshua fled the scene after shooting Miss Traynor, not as an act of indifference, but out of fear. He was distraught and remorseful. He contacted a friend and a counselor on what he should do. He wanted the assistance of a lawyer in turning himself in because he was afraid of the police and what they might do to him. Not only was he racked with grief, but he was also scared the police would kill him too. His fears were not unjustified. Police violence against black men has recently received national attention, but has been well known in the black community for decades. Trying to argue that him leaving her body there for more than a week, she wasn't discovered by her family until a week later. Him leaving her body there with a bullet in her brain was not an act of indifference, but he was scared. Josh Ellis, the one who just killed someone, he was scared. He was distraught. He was remorseful because leaving her there to rot is remorseful, shows remorse. That he wanted assistance of a lawyer to turn himself in because he was afraid of what might be done to him as a black man. Never mind what he had just done to someone who he claimed to love. There is no aspect of this case that the public defender, Mary Kay High, will not use race to excuse. There is no aspect. Now, there's another memorandum that Mary Kay High submitted to the court. And I will tell you that the data that she lays out has absolutely no place in a court of law. And what she's trying to do, before I get to the data set, she's trying to cherry pick data to suggest, to show that Pierce County judges are racist, that the outcomes show Pierce County judges are racist, that they sentence black offenders to higher sentences than they sentence white offenders. And in doing so, she cherry picks a single judge to look at that judge's record of sentencing black offenders versus white offenders. It says comparison of Judge Stephanie Arend, Judge Frank Cuthbertson, and Judge Catherine Stoles for the years 1999 through 2019. So she has these three judges up on a chart. And what she's really doing is trying to show that this one judge, Judge Stephanie Arend, sentences black defendants to 77% of the standard range, more than twice as long as the sentences she imposed on white defendants. I mean, it leaves out the fact that actually her sentences were much higher for Asian defendants, but clearly Mary Kay High doesn't care about Asian defendants. She's just concerned with alleged discrimination against black defendants. Now, if Judge Stephanie Arend was sentencing Josh Ellis on Friday, this would be relevant, I think. If you had a judge who was sentencing black defendants to 77% of the standard range, more than twice as long as sentences imposed on white defendants from 1999 to 2019, and that was the judge that was going to sentence Joshua Ellis, yeah, I think this would be relevant. Except Judge Stephanie Arend has nothing to do with this case. In fact, Judge Stephanie Arend retired in 2021. She was a Locke appointee. She wasn't the judge for Joshua Ellis's original trial. She's retired. She's been off the bench for 2 years. She's not the judge sentencing Joshua Ellis on Friday. What she's handed down for sentences to black offenders and white offenders has no bearing on this case whatsoever. So why is Mary Kay High including it as a way to suggest that Joshua Ellis should get a low-end sentence? That kind of cherry picking of data would never pass journalistic muster. It would never pass academic muster. And it certainly isn't fit for a court of law. Not to mention that in these numbers, Mary Kay High is taking it back to 1999, long before Washington State embarked on an effort to improve sentencing outcomes and to reform the criminal justice system. So could it be that by selecting a specific judge, a retired judge, and shifting the data set back to 1999, that Mary Kay High is doing that because that's the only data set that would reflect the argument that she's trying to make? I want to close this by reading the end of the sentencing memorandum from Mary Kay High. And really nothing in here is about trying to excuse, so to speak, what Joshua did or suggesting that he didn't do it. It is about trying to appeal to this judge's sense of or desire for equity and trying to weaponize race in the criminal justice system and trying to convince a judge that in order to make our justice system more equitable, you have to artificially deflate sentences for black offenders, no matter how heinous the crime they committed is. Mary Kay High, again, the public defender representing Josh Ellis, closed her sentencing memorandum like this. This court, by imposing the agreed upon recommended sentence, still honors the loss, grief, and anger of Miss Trainor's family and friends. Joshua Ellis will live every day of his life knowing he took the life of someone he cared deeply about. He will return to Kentucky and the support of his mother and family in Kentucky as soon as he is permitted. Once there, he will continue to live in a country still deeply flawed by racism. He will raise his kids in a world where they will be discriminated against simply because of the color of their skin. He will have to have the talk with his son. He will honor this court's trust in him by resuming a life dedicated to living a life committed to continued rehabilitation and restorative justice. You tell me in what world any of that is relevant to what Joshua Ellis did. Suggesting that this man, who admittedly had no criminal history, before he put a bullet in WENDI Trainor's brain, he had no criminal history. Yet you're suggesting that somehow living in a country deeply flawed by racism, raising his kids in a world where they'll be discriminated against because of the color of their skin, somehow contributed to him what? Having no criminal history, having a girlfriend who loved him, having a girlfriend who was willing to move across the country, put her life on hold for him. And when they broke up, he followed her back across the country to Washington State, came into this state, killed one of our citizens. And that what? He did it because he's living in a country that is deeply flawed by racism? Mary Kay High, shame on you. If it were up to me, you would not be able to practice law in the state of Washington. Truly. I believe you should be disbarred. Because what you're arguing for here, what you're suggesting, is that the only way to right the wrongs of this country's criminal justice system, the only way to do that is by taking it backward, is by taking the blindfold off Lady Justice and artificially deflating the sentences of Black offenders so that you can sleep at night. To argue that Joshua Ellis deserves a lighter sentence because he's Black is to argue that WENDI Trainor deserves less justice because she's white. Shame on you. That is not progress. That is the opposite of progress. But I know exactly why you're doing this, because you've read the room. You've read the room not only in Washington State, where so many people involved in the criminal justice system, so many people in political circles have a completely backward idea of what equality and equity mean. You've read the room. And you've read the room when it comes to the judge who's going to be sentencing Josh Ellis on Friday, Judge Andre Penoliver, a relatively young jurist, an Inslee appointee who's only been on the bench for a couple years and who has spoken out publicly about the need for criminal justice reform. I don't know if you believe the utter bullshit that you are spewing in this sentencing memorandum. I don't know if you are truly this racist, Mary Kay High. But I believe that you think the judge is. And I believe that you think that what you've laid out here is a brilliant way to let your client, a cold-blooded killer, off the hook for putting a bullet in the brain of the woman he claimed to love. Shame on you, truly.